Hi. So Ontario recently has introduced legislation that is designed to provide protections for gig workers. It's called the Digital Platform Workers Act. It takes effect on July 1st of this year. And this legislation is in part in response to a case involving Uber. Uber had an arbitration agreement that it required every worker to sign that required any dispute be held in the Netherlands. And also, the worker had to provide a deposit to take the case to arbitration. So the Supreme Court of Canada eventually found that unconscionable and set that aside. And in response, the provincial government of Ontario has introduced other rights available to gig workers. So basically, the concept is, first of all, the legislation sets up something called digital platform work, which basically means rideshare, delivery services, courier services that are provided through a digital platform. So it doesn't apply, by the way, to taxis and limos. So the legislation does set out certain obligations of the company. It requires a regular pay period be set and a regular pay day be set. It also requires that the workers receive minimum wage for their time, including driving time to a destination, not waiting time, but driving time. It also prevents the company from withholding any payments made to the individual at source. That is, the company can't say, well, you owe me this and you owe me that, and reduce the obligation it has to the worker. It also requires the company provide written reasons to suspend or kick somebody off the platform. If there's a permanent ban greater than, or a suspension greater than 24 hours, it has to give the worker 2 weeks notice, unless there's some issue of public safety and illegality, that is, I gather, no driver's license or some such thing, or willful misconduct on the part of the worker. So it also says that where there is arbitration, the arbitration must be held in Ontario. So that's the response to the Uber case in the Supreme Court. It also provides protection to the workers for any retaliation or reprisal taken by the company in response to them asserting their rights under the legislation. Unlike British Columbia's legislation, it does not classify the gig workers as employees. The BC law did that, and also entitled the workers to protection under workers' compensation and workers' health and safety legislation. The Ontario law does not do that.